Welcome to the Deep Dive. We're here to cut through the complexity and give you the essential insights from key legal sources. Today, we're tackling simple assault under federal law. Specifically, that tricky question of intent. Picture this, it's almost a classic scenario now. A major flight disruption. An unruly passenger does something offensive, really offensive, and the plane has to make an emergency landing. He gets charged with simple assault. So, the big question for the court, and for you listening, is this. Okay, the action was offensive, no doubt, but does the prosecution have to prove the guy intended to physically hurt someone? Or is just doing the offensive thing enough?
That's exactly the ambiguity in the statute, 18 U.S.C. section 113A5. And to really get at it, we first need to lay down the common law basics. You know, the two ways assault has traditionally been understood. Once we've got that sorted, we'll zero in on the physical contact part, what's often called battery. And then, we'll do a really structured breakdown of the Bayes case from the First Circuit. That's the one that gives us the clear element-by-element test for this kind of offensive touching.
Okay, let's start there then. The foundations. Simple assault is in the federal code, but the code itself doesn't spell out what it means. So how do courts figure it out? What are those two common law meanings they fall back on?
Right. So the general rule is that common law assault kind of splits into two paths. First, there's the attempt to commit a battery. This basically means the defendant tried to make unlawful physical contact. And crucially, this requires the specific intent to make the contact, but not necessarily the intent to, injure someone. The second path is creating a reasonable apprehension of bodily harm. This is more like the classic threat scenario, making someone afraid they're about to be hurt. It focuses on the victim's fear. But what's really key here, especially for the cases involving actual touching, is the underlying concept of battery. Battery itself, under common law, doesn't actually require intent to injure. The old cases say even the slightest willful or angry touching counts. And that's critical because it brings offensive touching, even nonviolent touching, into the picture.
That's a huge point. Battery doesn't need intent to injure. And, looking at the federal statute itself, that idea seems to track because you've got other parts, right? Like 113A1 talks about assault with intent to commit murder, and A3 needs intent to do bodily harm. Congress spelled out specific intent there. The fact that they didn't do that for simple assault in A5, well, that feels significant.
It absolutely is, and courts pick up on that contrast. The thinking is, look, if Congress wanted simple assault to require proof of intent to injure or threaten, they knew how to write that. They do it in other subsections. So their silence in A5 strongly suggests they were okay with adopting that broader common law battery standard, the standard where basically you just need to intend the offensive contact itself.
Okay, theory's clear. Let's see how it works in practice. Let's analyze the key case here, United States v. Bayes. First off, what are the essential facts? What actually happened on that flight?
Right, Bayes. So you have this passenger, Bayes, on a Delta flight, Atlanta to Manchester. He was already being disruptive. Then he approached a flight attendant, Karen Smoke. While she was getting something for him, he deliberately put his hand on her buttocks. Smoke described it as rubbing and grabbing, and importantly, another passenger nearby saw it too, confirming he was squeezing. This wasn't just a minor thing. It was serious enough that the captain decided to dump fuel and divert the whole international flight to Bangor, Maine. That's where Bayes was arrested and eventually charged.
Wow, diverting an international flight. Okay. And what was the core legal issue when his conviction went up on appeal?
The precise legal question was whether, to convict him for simple assault under this statute, the government absolutely had to prove he intended to injure flight attendant Smoke, or at least intended to threaten her with harm.
Got it. So what rule did the First Circuit use to answer that? Based on that common law battery idea we talked about, can you lay out the full rule and its elements?
Yes. The court basically said, look, for simple assault under Section 113A5, when it's based on physical contact, the battery prong, the standard, it's about offensive touching. The rule they articulated is this. It's sufficient to show the defendant deliberately touched another in a patently offensive manner without justification or excuse. And they broke that down into three distinct elements you have to prove. One, first, a deliberate touching of another's person. Two, second, that the touching was done in a patently offensive manner. Three, and third, a lack of valid justification or excuse for the touching.
Okay, clear elements, thank you. Now let's walk through the court's elemental analysis step by step. First element, deliberate touching. Bayes claimed it was an accident, right? How did the court handle that?
Yeah, he tried the "I was just reaching" defense. But the court didn't buy it for a second. The sub-issue was simple. Was the contact willful? And the court looked straight at the testimony. Smoke saying rubbed and grabbed, the other passenger saying squeeze. They concluded, look, regardless of whether he meant to harm her, he absolutely meant to touch her in that way. The manner of the touching itself made the accident claim, well, pretty unbelievable.
Yeah.
So element 1 met.
Understood. Deliberate contact established. Now, the second element. Patently offensive manner. This one feels a bit subjective. How did the court decide his actions crossed that line into patently offensive?
Right. Patently offensive can sound fuzzy, but the court leaned heavily on common law history here. They considered the location of the touch, the buttocks, and the manner, rubbing, grabbing, squeezing. Smoke's reaction, being angry and surprised, supported it. But the core reasoning went deeper. They cited legal history, even back to Blackstone, saying the law protects personal dignity and bodily inviolability. The principle is that any intentional unwanted touching can be offensive because your person is considered sacred. So this kind of groping. Given the context and the nature of the touch, the court found it was inherently, objectively, patently offensive. Element 2 clearly met.
Okay, so it's rooted in this idea of personal space and dignity. Makes sense. And the third element, lack of valid justification or excuse. What justification did Bays even offer?
Well, his excuse was pretty flimsy. He apparently claimed he touched her just to get her attention. The court dismissed that right away. There was no emergency, no need to brace for turbulence, nothing like that, and obviously no consent. So there was simply no valid reason, no legal excuse for that intentional offensive contact. Element 3 also met.
Right, so after finding the touching was deliberate, patently offensive, and lacked any excuse, what was the court's final conclusion?
The bottom line was that the evidence fully supported the simple assault conviction. The government didn't need to prove he intended to injure or threaten. They only needed to prove those 3 elements of offensive battery. Interestingly, the court noted the trial judge had actually told the jury they did need to find intent to injure. That was technically wrong, legally speaking, but it actually favored Bays. Since the evidence easily met the correct lower standard, the 3 elements, the conviction stood, affirmed.
That's fascinating. So the standard focusing on the offensive contact itself, not the intent behind it to cause harm, is really quite protective. It means things like groping, even if the perpetrator claims it wasn't violent, can still be assault. To really make this stick, what were some of those historical examples the court used, those kind of visceral ones that show even minor offensive touching counts?
Yeah, the examples really drive it home. One was Gates v. State. There, a conviction stood just for someone deliberately tapping or hitting someone on the buttocks twice without consent. No injury intended, just offensive contact. Another one, Guaro v. United States, held that non-consensual kissing is assault. Again, often not physically injurious in the violent sense, but a clear violation of personal dignity. And then Commonwealth v. Clark involved groping a minor. The touching wasn't necessarily violent, but it was sexually offensive, and that was enough for assault and battery.
Okay, so tapping, kissing, groping, even without intent to cause physical pain. The common thread seems to be violating someone's personal space and dignity in an offensive way.
Exactly. Yeah. It underscores that the law is focused on protecting your right to control who touches your body and how. The act of offensive violation is the harm, regardless of whether the defendant intended further injury.
This has been incredibly detailed, so helpful. Now, for someone listening, maybe facing an exam question or just trying to analyze a situation, how do we boil this down? Can you give us a quick step-by-step checklist for spotting and analyzing a potential simple assault?
Absolutely. A checklist is key here. Step 1, path check. First thing you ask, are we dealing with physical contact here? Or is it about words or gestures causing fear? That splits your analysis immediately into battery path or apprehension path. Step 2, apprehension path check. If it looks like fear-based assault, you then check. Did the defendant act intending to make the victim reasonably afraid of immediate harm? And did they seem capable of carrying it out right then? That's the focus for the apprehension path. Step 3, battery path check, the Bayes rule. Now, if there was physical contact, you basically set aside the intent to injure question for simple assault. You go straight to the Bayes elements. 1, was the touching deliberate? Intentional contact. 2, was it patently offensive? Look at context, location, manner. 3, was there any justification or excuse? Consent, necessity, etc. Step 4, conclusion. If you can satisfy all the elements for either the apprehension path or the battery path using the Bayes test, then you've likely got simple assault. Keeps the analysis clean and focused on the right standard for the right type of facts.
Perfect. So the big takeaway really is that simple assault. Well, it's not always that simple legally, is it? It involves digging into these common law roots, focusing on protecting dignity. And that claim, oh, I didn't mean any harm, just doesn't fly if you intentionally made offensive contact.
Precisely. And think about the Bayes case consequences: diverting an international flight, over an offensive touch. It shows just how seriously the law takes protecting bodily autonomy, even from nonviolent intrusions. It definitely leaves you with something to mull over, though. As society changes and maybe ideas about personal space evolve, especially in crowded modern life, could we ever see courts start to carve out exceptions? Or will that line of patently offensive, rooted in protecting dignity, remain pretty fixed? It's an interesting question.
It certainly is. Thank you so much for breaking down this complex area with such clarity. We really hope this deep dive gave you, our listener, the structured analysis you need on simple assault and the intent to offend.